That's right. And we're eagerly awaiting, as we sit here right now, some Supreme Court results that could, I think, have really dramatic consequences for the country. But we're going to start with some results from yesterday that actually already have dramatic results for the country. So, Krystal, this is in the case of Moore v. Harper.
Yep. So, guys, go ahead and put this first one up on the screen. This is from More Perfect Union. In a 6-3 decision, Supreme Court decides Moore v. Harper and rejects the so-called independent state legislature theory. I'll tell you in a minute what that is, which claims state legislatures have total authority over elections. This ruling ensures that courts can still strike down state election laws and maps. So here's the backstory. There was a dispute between the North Carolina legislature, which at that time was and still is dominated by Republicans, and the North Carolina state courts, which had more of a liberal bent. The court said the maps you drew, the gerrymandered maps you drew, these are wrong, these are unconstitutional. And the legislature argued, and this is the case that went all the way up to the Supreme Court, that you don't get to have a say in this. There's this clause in the Constitution that says it's up to us, the state legislature, to determine everything with regard to elections. So you don't get to have a say in this. This theory has been kind of fringe. It's been floated for a while, but the Supreme Court has never affirmed it. It came up in the context of actually Bush v. Gore. There were some dissenting opinions that made reference to this theory and gave it a little bit of credence. But the court yesterday pretty clearly saying we don't agree with that, and that this really goes to the core of what judicial review even is. They mention Marbury versus Madison in the decision here. That is a seminal case that established that federal courts can strike down laws. It basically established judicial review. Right. And they're like, so yes, we think that courts have power and jurisdiction over this. And the fact that it's mentioned in the Constitution that state legislatures have power doesn't mean that they have free reign to do whatever they want. This became really important, Emily, as you know, because this was one of the theories that was floated in 2020 by people who wanted to hand the election to Trump, even though he had lost. So in a state like Georgia, the argument was, sure, voters might have voted for Biden, although they don't really accept that, but maybe they voted for Biden. But the legislature, since it's packed with Republicans, they can pick whatever electors they want. They don't actually have to listen to the will of the people. And one of the theories here was that because the legislature had complete control, they could just discard whatever else had happened and they could pick their electors. So it had far-reaching potential consequences here if this one went the other direction. However, it did not, and majority on the court said, nah, we're not buying it. Courts still have jurisdiction here.
Federal elections are one of the most interesting sources of tension, not just on the right, but I think when we talk about what America is, because judicial review obviously is germane in this case, but it's also this idea that, like, the right at least supports federalism. So the state's ability to determine what's best for its people and for its voting, and what that creates is this disastrous patchwork of different election laws. And that's where you have conservatives in some cases saying, well, you actually really need a more robust federal government policy when it comes to election law, because we have this insane patchwork of different laws, which in 2020 was a disaster with COVID in particular, that you have very different early voting, for instance. You have very different time periods that people are actually going to cast ballots, very different laws for how they cast those ballots depending on where they live. And, you know, maybe that's the sort of blessing of federalism, or it's the sort of disaster of it. It's a double-edged sword of federalism. And this is from Slate. They write, in the last part of his majority opinion, that's Chief Justice John Roberts, who wrote the majority here, he got the liberal justices to sign on to a version of judicial review that is going to give the federal courts, and especially the Supreme Court itself, the last word in election disputes. The court held that, and this is the quote, state courts may not transgress the ordinary bounds of judicial review such that they arrogate to themselves the power vested in state legislatures to regulate federal elections. And that's just all of it right there. Like, that's the nut of the issue.
Yeah, so put the second element up on the screen, because while they did sort of, they did not accept independent state legislature theory, they did put a little bit of a caveat here, and they did give themselves a little bit of wiggle room. So part of what they said in the graphic that's at the top right of the screen, although we conclude the Elections Clause does not exempt state legislatures from the ordinary constraints imposed by state laws, state courts do not have free reign. State courts are the appropriate tribunals for the decision of questions arising under their local law, whether statutory or otherwise. They cite a case there. At the same time, the Elections Clause expressly vests power to carry out its provisions in the legislature. So expressly saying there, state courts do not have free reign. So they're saying there may be some limiting principle here if the state courts, in our view, as the Supreme Court, get way on over their skis in terms of rejecting what the state legislature does, but in no way do they define what that limiting principle might be. Now, without getting too much into the weeds, it may,
we're already there.
Facts. This may become really relevant really quickly because there are a number of states where you have a mismatch between the partisan valence of the legislature and the partisan valence of the courts. The primary one people are pointing to, Emily, is Wisconsin, where you have a Republican legislature, you have a gerrymander that was drawn by Republicans, and you have a state Supreme Court that, I don't know if you guys just remember, there was just a huge election where a liberal was elected, very clear and ran as a liberal. And this actually gerrymandered lines was one of the things that she ran on. And so you're likely to have this same dispute. You actually already have this dispute between the Wisconsin State Supreme Court and the Wisconsin legislature. So is the Supreme Court going to say, yes, it's within that court's jurisdiction? Yes, it's fine for them to strike down the gerrymandered lines drawn by the Republican legislature? Or are they going to use this wiggle room that they gave themselves to go in the opposite direction when it comes to Wisconsin? There's a lot of analysis out there that there's going to be an immediate test to what the sort of limiting principles here are and whether the court is really giving state courts kind of, a blank check to do whatever they want with regard to the gerrymander, within the bounds of whatever their judicial process is.
Right, and that's where some people I've seen on the right, legal people, I'm reading from Ilya Shapiro right here on Twitter, who's at the Manhattan Institute, and that's where some people are saying, well, Justice Roberts sort of pulls back a little bit and has a quote, middle-of-the-road decision. He declined to adopt a standard, as Ilya writes, for determining when state courts cross the line, to your point, or even to say whether the North Carolina court did so here.
Yeah.
So this is a ruling that doesn't actually even weigh in on those questions where it could have. And so this is where Ilya says, we basically have to wait until the justices are forced to make that hard balls and strikes call that the Chief Justice referenced at his confirmation hearings, and this decision stops short of doing that. So these questions are now up in the air going forward.
Yeah, so they haven't really clearly defined where the boundaries of state court power lie and where it butts up against the state legislature. But, zooming out from this, the reason people were really watching this closely, this particular case, was because of what happened in 2020 and fears that we could see a repeat of this, especially with Donald Trump, very likely the Republican nominee again. And, I think it's likely, you can't say 100%, but I think it's likely that they have closed the pathway to them being able to, appoint a fake electors slate in a red state like Georgia and just completely overrule the will of the people and do whatever they want if they happen to have a legislature that is pro-Trump. So it seems like they've more or less shut the door to that, although they've given themselves a little bit of wiggle room. But, this was one of the cases that liberals were really, really concerned about. And frankly, I think everybody should be concerned about because we do want the will of the people to actually matter in our democracy. And so this is one that people should feel fairly good about, that it went in the direction of saying, like, no, you can't just do any old thing because you happen to like, one outcome over another outcome.
It's so interesting how when we're hitting a fever pitch, I think culturally, some of these areas of tension that when you have like more social consensus, like in your constitutional system, start to break down. And I feel like you start to see that kind of first. Like this is where these mechanisms that worked for maybe decades, certainly we've had issues with this throughout American history, but it's just a good example of how when we're not getting along as a country, you start to see it show up in some like warning signs like this.
Yeah, I think that's right. Hey guys, if you like that video, go to breakingpoints.com, become a premium subscriber, and help us build the best independent media organization on the planet.
That's right. We're subscriber funded. We're building something new. We want to replace these failing mainstream media organizations.
So again, to subscribe, it's breakingpoints.com.